Be ready. Start. From the perusal of the entire inquiry report, it transpires that on charge number 1, the inquiry officer clearly stated that the entire process of acceptance of tender was completed unanimously by the tender committee. Hence, it would not be proper to hold the petitioner guilty of the charge as far as charge number 2 is concerned. The inquiry officer concluded that in the light of the explanation of the petitioner, he could be partially exonerated from the said charge, but later on stated that charge was partially proved against the petitioner. As far as sixth charge is concerned, it is the clear-cut finding of the inquiry officer that as the sales tax amount was deposited, the administration did not suffer any financial loss. The inquiry officer also recorded a finding over charge number 7 that it had been accepted that Sri Atma Ram Srivastav has proceeded in the matter in accordance with the established practice, and no bad intention can be attributed to him, as the firm had deposited the entire amount of the unused answer books, including the sales tax. Hence, his case deserves to be considered sympathetically, particularly when he has been retired from service. After the submission of the report, the disciplinary authority issued a show cause notice to the petitioner. The petitioner submitted an explanation against the show cause notice. Thereafter, the impugned order deducting 5% per month from the pension of the petitioner was passed by the disciplinary authority, that is, the state government. The question as to whether the petitioner was guilty of such an act of misconduct or negligence and discharge of his duties while in office, which warranted such a drastic action of deprivation of 5% from pension, results into grave consequences as far as pensioner is concerned. It has also to be examined as to whether the deprivation is correlative to or commensurate with the gravity of such an act. Para. We have discussed in details the report of the inquiry officer, from which it transpires that the petitioner had not committed such an act of misconduct or negligence in discharge of his duty while in office, which would warrant such a drastic action. The punishment awarded does not commensurate with the gravity of the charge of misconduct or is not correlative with the gravity of the misconduct or irregularity. At the most, it can be said that the petitioner has committed mistake or an error in not getting the security money deposited at a particular time and getting the agreement executed after some time, but the administration did not suffer any loss. The inquiry officer himself did not attribute dishonest intention or motive on the part of the petitioner, and in the concluding part of his report, the inquiry officer recommended for sympathetic consideration of the case by the state government. It seems that the concluding part of the report of the inquiry officer was not considered by the state government in its right perspective. We are of the view that the petitioner has not committed such an act of grave misconduct or irregularity which warranted such a drastic action at the evening of his career. Only certain lapses, mistake or error which are technical in nature can be attributed to the petitioner. there was no bad intention on the part of the petitioner to cause wrongful loss to the state government and wrongful gain to himself or any other person, the action does not commensurate with the gravity of the alleged charges of misconduct or irregularity. Stop.